Don't just stand there, sue someone. Hey guys, Darrell Brooks is of course ultimately responsible for his criminal acts, but there's no doubt his vile behavior was assisted by others, including the system, which kept putting him back on the street to commit ever increasingly violent crimes, to his mother who kept bailing him out and providing the automobile he used in the parade massacre. They may bear some moral responsibility, but do they bear legal responsibility? Let's look at the system first. Through a collective failure of every actor in the system, Brooks was put on the street for the low bail of $500 for shooting at his nephew and a female, and being found as a felon possessing a firearm and likely drugs, and $1,000 for punching and running over Erica Patterson. Now, the point of bail is to ensure the defendant does not flee from the proceedings and sometimes to protect the public. Brooks was known to flee and not attend proceedings, and he was known to be a danger to the public, so the bail was in no way appropriate. In fact, they had found he was likely to commit another crime, but his bail was reduced anyway. So there were two things operating in Brooks' favor beyond the sometimes frustrating leniency of the system to violent people. First was COVID. The response to that brought many criminal justice systems to a near halt. With trials suffering extreme delays, people who had no business being let out on the streets were let out on the streets. There were lawsuits to simply let people out of prison as some kind of response to COVID. Second is the anti-bail movement. Now, I'm definitely sympathetic to the issues of excessive or unnecessary bail, but like anything these days, extremists hijack a reasonable position and exploit it, agitating for bail to be reduced to nothing or pointlessly low levels. As I said, bail is meant to ensure against flight risk and to protect the public. If neither of those are a demonstrated concern, there shouldn't be bail. But if either are, pretrial detention, however it's done, whether it's through bail, should be sufficient to achieve the purpose. And Brooks' bail was a formality, and it didn't ensure that he would attend the proceeding or protect the public. So what can you do about it? Well, you can vote. DAs and judges, while they're Wisconsin state employees, they are elected. So either vote someone different in or convince the persons who are there to change policies to avoid being voted out. The DA involved in the low Brooks bail has said there was an internal review and the bail was, as any Captain Obvious would concur, too low. He said he wasn't making excuses, but it was the fault of a young staffer, a young DA, inexperienced DA. I think it's good of the DA to at least admit that, because the North Korean-like voting percentages for the DA race there suggest that voting is just a formality. The real accountability would be in a party primary, I suppose, because it's not changing after that. But be careful what you wish for. There are Soros-style candidates around the country trying to hijack primaries. They tried to do it here in Wake County. And when they succeed and win the pointless general election, then crime goes up. The fact is, Brooks was only unique in the scale of his evil. In 2021, with around 117 attempted or homicides, 25 of those were out on bail, and a lot of those were $1,000 or less. So Brooks was just the most noticeable of this. Many, many people around the country have been robbed, assaulted, raped, or killed by people who should have been behind bars. These cases just don't get the individual attention the Brooks case did. So that's voting and what's going on. Can you sue these people, the judge, the DA, for this low bail? No. Wisconsin statute 893.84 provides no suit may be brought against, it's got a lot of things in here, but basically any agency for intentional torts of its officers, officials, agents, or employees. And you can't bring a suit against any of these people for acts done, and this is the key part, in the exercise of quasi-judicial functions. Judicial or quasi-judicial. Well, guess what? That's what judges and DAs do. Even the Supreme Court has said, no suing judges, bro. So that's not going to happen. You can't sue them, basically. The state has sovereign immunity, and it can remove that at its will, and it has only done it in certain cases. But judicial immunity is not surprisingly, is one of the most protected. Not surprising, because who's making the rules? Now, this kind of immunity, sovereign immunity at state and then at subdivision level, it's really complicated. But for purposes of this video, the best, clearest answer I can give you is no, they can't face suit, because the DA and the judge are engaged in judicial and quasi-judicial functions, so they have immunity. And doesn't mean no one anywhere can be sued involved in the government for this, but if you're looking to sue the DA and the judge, nope. Okay then, another question people have asked about, what about Brooks' mother? People say she should be jailed or sued or both. Okay, but for what though? Let's go over that. I hear from people two ideas that to me seems supported by solid evidence. First, she bailed him out. Second, she gave him the Ford. So on the issue of bail, I cannot see liability here, criminal or civil. The court system set to bail him out. The judge and the DA did that. The person posting the bail is liable for the loss of the bail money, and that's all the system asks of them. I don't see any basis to sue her for merely doing what the state approved. And certainly I don't see any way to put her in jail for getting him out of jail on the terms the state said was okay to get him out of jail. The vehicle, though, that's another matter. If she allowed Brooks to take it, I think she does face an issue. Let's look at the criminal side first and then the civil. On the criminal side, Wisconsin has a statute, 939.05, called parties to a crime, and it includes directly committing the crime, aiding and abetting, and conspiracy. Now, I think about everyone would agree Brooks' mother did not directly commit the crimes for which he was convicted. He did it. Also, there's no evidence she was part of a conspiracy for the parade attack to happen, or even really that he planned that far in advance in the first place, but no evidence that she was part of that. This leaves aiding and abetting. Abetting is out. There's no evidence she encouraged him to attack the parade, and it's pretty much what abetting means. So that leaves aiding, and that would be the provision of the vehicle to Brooks. Now, of course, if he did take it without permission, that's out. And in the 911 call she made the day of the attack, she told the police that he stole it, and she didn't know he had it. Let's listen.
I think the incident that happened with the red SUV is my truck. My son stole my truck. I didn't even know he had it.
All right, so that was her story at the time. But let's assume she was letting him use it, because I think, there's a case for that as well. The statute says intentionally aids the commission of the crime. This leaves open the question of whether the mother was intentionally aiding any crime that she would know about, and if in aiding him in the crime she might know about, let's say driving without a license, because I think she did know about that, whether doing that, giving him the vehicle when he doesn't have a license, that's not the attack, right? So she's not really aiding the attack there, but she can be considered to aid the attack if the attack at the parade is considered a natural and probable result of the crime that she was helping with, let's say driving without a license. Now, I think the case is strong. She, of course, knew he had no license. She was charged with allowing him to operate the vehicle without a license in 2019. At the same time, he was charged with operating it without a license. So she knew she was criminally charged with it. But the issue is whether aiding him at that crime, driving without a license, to the degree it's a crime, leads to a natural and probable result of intentionally murdering people. People drive without licenses all the time, and it doesn't mean they're intentionally trying to kill people. It usually means they're disqualified for some reason, or they don't have insurance or whatever. So this is an issue for criminal responsibility for her. There isn't evidence Brooks' mother wanted him to commit the parade attack or knew that he would do it if he drove the SUV. Cases where, say, you go with someone to rob someone with a weapon and a person gets injured or killed, that's a natural and probable result of armed robbery. You can't say, well, I was aiding and abetting, the robbery, but not the killing, because it all happened as a course of events that logically are connected. You go there with a weapon to rob somebody getting hurt, there's a pretty good chance it's going to happen. Letting someone drive without a license isn't a straight shot to running over a parade line of people on purpose. It's not as connected because there's so much driving without a license. He'd done it for years. Now, granted, he did hit Erica with a car shortly before this, so I got that. But still, this seems to me on the criminal side a very weak case legally. It's just my opinion, and it might be one of a couple reasons this hasn't been charged. The other reason being they just don't want to punish the mother. So I think it's really down to this natural and probable consequence. Who would foresee that he would do this with his vehicle? Now, things are different on the civil side. There's a cause of action called negligent entrustment. Again, if he took the vehicle without her permission, like she tried to claim in the 911 call, that could be out. But if he was allowed to use it, as he habitually had done in the past, and if he was living in it, how can you say he wasn't allowed to use it? Then the claim exists when the vehicle owner permits another person to operate a vehicle, even though she knew or should have known that the borrower intended or was likely to use the vehicle in a way that would create unreasonable risk to others. So, if she lets you borrow the vehicle, but she knows you're a terrible driver or you drive recklessly, there's liability there. So you have a couple of advantages here the criminal case didn't provide. First, you just have to show the person should have known of a risk to others, compared to the criminal requirement of knowing of an intended crime, or that the crime that did occur was the natural and probable result of the crime that you were helping with. And that's tenuous. Instead of just knowing there's a risk of someone getting hurt or whatever, it could be by an accident. So it's much easier on the civil side. And second, on the civil side is the burden of proof, more likely than not. So if you charge a crime, you have to prove beyond a reasonable doubt this knowledge of a crime and that this would be foreseeable and probable and all that. You don't have that on the civil side. You just have, is it more likely than not that she knew there was a risk to others? Not even necessarily a crime. He could have just been driving bad. So she knew he was involved in hitting someone days before the parade attack. So it's pretty clear to me that if she let him use it, she knew or should have known that he was dangerous with a vehicle, that he was operating it erratically. So to me, unless she shows Brooks was operating the vehicle without permission, that he stole it, this is a solid civil claim. So finally, yes, someone besides Brooks could face liability for this situation. Now, I'm not getting into whether any other government agencies or other entities could face any liability for how they handled the parade itself. Did they have adequate security or whatever? Not going down that rabbit hole. People didn't ask me. Thank God. I'm sticking to the DA, the judge, and the mother. So what does it get you, though, that you got this case potentially against her? Because generally when you file civil suits, you're doing it to get money. That's the point of it. You get paid by insurance if it's available. And if it's not, or it's not enough, you get to take what she legally has to take. Now, here there may not be coverage from her insurance. Insurance policies are very complicated. It's nice to know handy rules about them, what you heard about them, how it worked in your case or your friend's case. But trust me, the actual rules are very state and very policy specific. There's no uniform policy in Wisconsin. How the companies phrase things into policies, which they have to change as statutes change and cases change, determines the outcome a lot of times on whether there's coverage or not. So, for example, policies in Wisconsin can exclude coverage for intentional acts of harm, such as what Brooks did, as long as they phrase it right, or the use of a vehicle beyond permissible scope. And depending on how the case sets, if there's no underlying liability, for example, the person was intentionally doing something or they were beyond the scope, then you probably can't engage the policy for negligent entrustment either. You have to have some underlying liability for the policy to kick in for negligent entrustment. At least there's some cases that say that. It just depends. It is interesting that Wisconsin statutes say that for permissive use, if you let someone use a vehicle who's not supposed to, they don't have a license or whatever, so even if you're violating the law like that, if you let them use it, that is still considered permissive use for purposes of insurance. But what are we arguing about over here? What kind of insurance has she got? Minimum coverage is $25,000 per injured person and a maximum $50,000. So something between zero and those numbers as far as her insurance goes, unless she paid to have additional insurance. And what do you think the odds are of that? Now, if her insurance declines to cover or offers the limits, and they're obviously under the damage caused as they are, the person's injured may be covered under their own policies, which can cover being struck while being a pedestrian by someone who is either uninsured or underinsured. These kind of cases can be dealt with without filing suit, and sometimes they are. All we know right now, at least from what I see in court records, it appears no suits have been filed against Dawn Woods. We don't know if insurance companies have worked behind the scenes, or if nothing has happened, or if something will happen, or maybe a suit will be filed later. We just know how it currently is. Now, insurance settlements, though, they don't get at the idea of Woods actually experiencing a legal consequence of her actions, whether she should or shouldn't. A suit would have some impact to that, and that hasn't been filed from what I see. Sometimes people sue and get a judgment not expecting to collect from the person, but although the person might be broke at present, they have that judgment in case the person comes into money later. I mean, maybe they win the lottery or something like that. Plus, it's a burden to have a judgment on you for your credit and stuff. So who knows? But no suit like that's been filed from what I see. So perhaps the victims don't want to pursue this, or at least not yet. They've held Brooks accountable and maybe they want to get past the pain. I don't know why there haven't been suits filed. But there are your answers as I see them. If I missed something, let me know. If you think so from a legal standpoint, please put a reference in the comment if you're telling me that I was wrong on this or missed that, because I'll look it up. And I'm glad to amplify or correct. But without a reference, I have to assume it's from your imagination, because that is what it is 99 times out of 100. I'm not talking about you. You're really smart. To close this out with something slightly less serious, in checking on this, I did see Dawn Woods had been in a civil case before. It dealt with a mortgage foreclosure. And what do you know? She appeared and filed an answer pro se. In a bizarre court note, it shows her present for a motion hearing, pro se as defendant. This was after the answer was filed. And the attorney for the plaintiff, some kind of housing authority or whatever, checked in as well. And the plaintiff's attorney told the court, look, I got to go over this other court because I got a case calendar over there to be heard. And the court said, okay, that's not unusual for calendar calls on a day. And then you set up the hearing time. So the court said, yeah, go over there and take care of that. We'll see you in a few minutes. But over an hour went by and this attorney never came back. According to the court records, I wasn't there. The court called the other courtroom. Hey, that lawyer over there, what's up? And no dice. And then sent a mass email to the other courts, but they didn't end up making contact with this lawyer. So the court said, you're not here, I'm throwing this case out. So the court dismissed it without prejudice, which meant it could have been brought again, but this was like a decade ago, so it wasn't. The point of this is Brooks' mother was a pro se litigant, and she has a 1-0 record. You can't make this up. All right, until next time. Thanks, bye.